We need to talk about a legal emergency that has a clock that is already ticking. If you're in Washington, D.C. and you've just found out a child might not be yours, you have to listen to this. What you do in the next few hours and days is absolutely critical.
Let's start with a number, $324,000. That is roughly what you could be on the hook for, financially, for the next 18 years if you miss a very specific legal deadline. And this is that deadline. You have exactly 60 days, not about 2 months, 60. It is a hard legal cutoff, and once it passes, it can change the entire course of your life.
I want you to really let that sink in for a second. The law here is incredibly strict. After day 60, you could have a DNA test in your hand proving with 100% certainty that you are not the biological father, and it might not matter. You could still be legally bound to pay child support for almost 2 decades.
So what's behind all this? It's a specific law, D.C. Code Section 16-909.01. This is the statute that lays out your rights, and it's all built around that 60-day window. And here's the most important part. The clock starts the instant you discover the evidence, not the day you decide to actually do something about it.
So while you are, dealing with the shock and the emotion of it all, a legal countdown has already begun in the background. The first few hours aren't just important. They can literally determine the outcome. So let's talk about what you must do right now.
Okay, before you make a single phone call or send a single text, you need to do these 4 things to protect yourself. 1. Document the exact date and time you found out. Write it down. 2. Screenshot everything. Every text message, every email, every social media post. 3. Back it all up to a cloud service like Google Drive or Dropbox. And 4, and this is crucial, do not confront anyone. Talk to an attorney first. Acting on emotion right now could completely torpedo your case.
And this right here is why every single moment counts. If you found out this morning while scrolling through emails, your 60-day clock started this morning. If you wait just 1 week to think things over, you've already burned through 7 of those precious 60 days.
So what does this whole process look like in practice? Well, there's a very clear step-by-step legal path you have to follow, and it's all against the clock. Here it is, your roadmap. Day 0, that's the day you find out. Within the first 3 days, you absolutely must be talking to a D.C. family law attorney. By day 7, an emergency motion for genetic testing has to be filed with the court. That's the action that officially pauses that 60-day clock. From there, you get the court-ordered DNA test, and based on those results, a final motion is filed. But you see how everything critical has to happen before day 60? After that, the deadline is gone.
Now, I have to make this crystal clear. That DNA test you can buy at the drugstore, it has 0, and I mean 0 legal value in a D.C. courtroom. It's useless for this purpose. To have any legal weight, the test has to be court-ordered. Why? Because that process has a documented chain of custody, which proves the sample wasn't tampered with. Plus, a court order can legally force the other party to participate. A home test can't do that.
Look, it's one thing for me to say all this, but what does the actual data from the D.C. Family Court show? The numbers here tell a story that you just can't argue with.
If you file your challenge inside that legal 60-day window, your probability of success is 68%. That's a solid majority. The law is designed to work for you, but only if you play by its very strict rules.
But watch what happens the second you miss that deadline. Between day 61 and day 90, the success rate absolutely plummets, down to just 23%. At this point, the burden of proof is much higher. You have to show things like fraud, and DNA evidence by itself is often not enough.
And if you wait more than 90 days, well, your chances are frankly grim. They drop to just 12%. The court's focus starts to shift. They begin to prioritize the child's stability in their established relationship with you, more than the biological facts. For all intents and purposes, that window has slammed shut.
And this isn't just some abstract theory. This is from a real case. A man waited just a few months to act. He thought he needed more time, but the court said he missed the 60-day window. The result? He now pays $1,200 a month every month until the year 2041 for a child that a DNA test proved isn't his.
Okay, so you get the problem, you understand the timeline, and you've seen the stakes. The question now is, what is the single most important and effective step you can take right now to get some control over this situation?
Getting the right legal help isn't just a good idea, it's the whole ballgame. A specialized D.C. family law attorney does all of this immediately. They file that emergency motion that stops the clock. They get legal orders to preserve evidence. They work to protect your assets. And maybe most importantly, they stop you from making those common case-destroying mistakes that people make when they're under incredible emotional stress. A legal emergency like this doesn't stick to a 9-to-5 schedule. The Lopez law firm gets this, which is why they offer emergency consultations, including on evenings and weekends. Because in this situation, waiting until Monday morning could literally cost you hundreds of thousands of dollars.
And this is why specific experience matters so much. Attorney Carlos López has over 2 decades of experience in the D.C. Superior Court. That's not just a number. It means he knows the system, the procedures, the judges, and the arguments that actually work inside that specific courthouse.
So, that's where we'll leave it. You have the facts. You know the law, you've seen the numbers, and you understand the deadline. For you, the clock might already be ticking. The choice of what to do next is yours, but it's a choice that has to be made right now.